Hi, California probate attorney Scott Grossman here, and today I'm answering the question, how do I know if a typewritten will is valid in California? California does impose a few requirements about that have to be met in order for a typewritten will to be valid, but there aren't that many of them. The first requirement is that the testator, that's the person who has died, the person who has created the will, is mentally competent at the time that will was signed by them. The second requirement is about the signing of the will itself. It's either got to be signed by the testator, or the testator can direct somebody else in the testator's presence to sign their name for them. Now, they don't have to sign it like a person who's acting under a durable power of attorney signs it. They're actually going to sign the testator's name. And if this is being done correctly, there will actually be a page attached that says that it was done, or there'll be some part of the will that says it was being done this way. Otherwise, obviously, there's going to be a claim of forgery. For a typewritten will, there have to be two witnesses to the signature. Now, that may be the testator's signature. It may be the person who signed the will at the direction of the testator, but witnesses, not a notary public. Witnesses are required to make that will valid. And finally, the last requirement is about the contents of the will. The will itself has to dispose of the testator's property. Now, dispose sounds a little funny. That's just legal language to say there are directions given about who gets the property now that the testator has died. So that's it. Those are the four requirements to determine whether a typewritten will is valid in California.